Good morning. Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Belize, monitoring hearing in CCJ appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Saunders, President and the presiding judge.
Good morning, Council. Good morning, all.
Mr. Justice Anderson.
Good morning, Council.
Madam Justice Rajnath Lee.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please you, Your Honors, good morning. Leslie Mendez, together with Alistair Jenkins, appearing on behalf of the appellants. Present with us today, as well, Your Honors, are members of the Toledo Alcalde Association.
Yes, good morning again to you all.
Good morning, Your Honors. I, Andrew Marshallek, appear together with Ms. Samantha Tucker for the respondent. We also have with us Mr. Greg Chuck, who is also the Commissioner of Indigenous Peoples Affairs. He'll be appearing with us as well.
Okay, good morning, Mr. Marshallek and your team. And I gather we also have Professor Celorio. Good morning to you. And is the Environmental Commission also represented here?
They're not represented, they're just visiting us, President.
They're just visiting.
Yes.
Ah,
Yes.
okay, I see.
Yes.
Yes, we have the Environmental Commission visiting us and who will view the proceedings. I would like, first of all, to invite Ms. Mendez to give any speaking points that she wishes to convey, premised on the compliance report. And if I were to afford you that facility, Ms. Mendez, how long do you think you would be?
I think just about maybe 3 minutes, 5 minutes, Your Honors.
We have set up. You'll be longer than that because we would want to ask questions. Okay.
Well, save for questions, Your Honors.
I see. Yes. Okay, well, please proceed.
Grateful, Your Honors. We have essentially set out, at least insofar as the participation of the appellants is concerned, we have set that out in our compliance report. So just grateful for the opportunity to address some of the issues that were raised in the respondents' report. We start off just by at least setting out our position with respect to the indication that there's a desire or an intention to not renew the contract of Ms. Celorio, of Professor Celorio. In that sense, Your Honors, we would be in disagreement with that, and we are disappointed that it's the first time that we're hearing that this is the intention of the respondents, as the appointment of the authority was something that was done with the agreement of both parties, and so mutually both sides are invested in the appointment of the authority. The reason why we feel very strongly about retaining the authority, in addition to the fact that I think that the authority has proved very valuable in guiding us in these hearings, especially as it concerns clarifying some issues on international standards and indigenous people's rights. Right now, what we see in the respondents' report, we see that they are reporting that there's an increase in the intended activities in the community, so that there are various projects that they indicated that are undergoing FPIC. The function of the authority fundamentally was paragraph 4, and paragraph 4 deals with FPIC, and it's an interim measure pending the finalization of the legislation, of the policy, and of the mechanism to delimit the boundaries. And so I'm struggling to understand why at this point, when we're seeing an increase in the need for guidance on FPIC because it's being implemented in a number of communities with respect to a number of projects, why is it that we are at this point contemplating the non-renewal of her contract, where I think that right now specifically, we would want to retain the avenue that the communities have to raise any concerns with respect to FPIC. In fact, one of the proponents or one of the developers that is renewing or re-engaging the communities is US Capital. And the authority has provided a report, has looked into the activities of US Capital and the communities, understands the context. And so I think that it's ill-advised at this point to be speaking about the non-renewal of the authority. Because she will prove invaluable. I also did not really see much in the respondents' report that substantiate that the complaints that have been made to the authority have in fact been addressed. There's a blanket statement that says that, but as far from our perspective, we do see that there are still complaints that have been unaddressed. For instance, Indian Creek, that's still a situation that continues. So,
Sorry,
so
I'm not sure that I follow you there. There's complaints that have been made to the authority or
yes,
that have not been addressed?
Indeed. So far, the authority has investigated and issued reports with respect to 8 incidents, so 8 complaints. I can speak to at this moment, at least with respect to Indian Creek, that has not really been addressed or remedied. And so I make that point to say that in the report, there's not much to show, in fact, that the complaints have been addressed in a way that then justifies the non-renewal of the authority. Essentially, what I think or what I understand from what the respondents are saying is that we don't really need the authority anymore, and that we will need her perhaps on an ad hoc basis, and that's when we would engage her. I'm also not quite sure how that would work, because it's an authority that is established and that the communities engage. It's there to ensure a mechanism for the communities. So I'm not sure how the communities would then be able to engage the ad hoc process that the government is proposing. So we do vehemently disagree with respect to the indication that the authority's contract might not be renewed. We would urge that the authority in fact be retained. More so because of the increase in the activities. Another thing that we wanted to highlight, in addition to the non-responsiveness of the government, which again I think we have set out, is that in the respondents' report now, in the compliance report, is that I think we were anticipating getting a sense of where our communications are. Why is it that we haven't really received any response? We have made requests for meetings, and that is all but completely bypassed in the report. And in fact, the report, and I might be misreading it, but the report seems to suggest that the roadmap is agreed upon and finalized. That's not our position. And in fact, that is not what the parties discussed at our main meeting that we reported to the court very shortly following that meeting, and we also reported back again in the joint report. Our understanding is that that's not finalized, that we would present our comments, and that we would seek to meet to continue to be in dialogue and attempt to get to an agreement on the roadmap. here we highlight that the roadmap is actually an amendment of the December 2018 agreement. So there's already an agreement about the main components of implementation. This roadmap seeks to tweak it, not tweak it, actually change it drastically. In the report, all we see repeatedly is that we would be consulted on the timeline, not on the actual substance of the roadmap, which is something that we have been awaiting to hear from the respondents. What is their position with respect to some of the things that we have highlighted in our letter and as well as in the meeting. So right now we are, just to conclude the initial reaction, right now we are very concerned about just the non-responsiveness of the government and the really inordinate delay in actually meeting and engaging in any meaningful dialogue, which I understood and very much thought that was the hope following that May meeting, which I thought was productive, but unfortunately there has not been much dialogue or engagement with the appellants following that May meeting. So I conclude my initial comments there, Your Honor.
Yes. Have you received any information on the auto delimitation process and verification? Any update on that?
Yes, I can provide an update to the court as to the activities that we have done. There's 25 communities that have consented to the auto delimitation following the delimitation principles and methodology. There are 15 communities that have signed interboundary agreements. And then there are other communities are engaging in the process, but they are just in various stages of negotiation and harmonization. I do know that that the commissioner did send us a communication with respect to the auto delimitation, essentially indicating that they would not be either undertaking verification, the verification aspect of the auto delimitation, or they would not be accepting our funds. Following that communication, what we had suggested is that we meet so that we can get to some sort of common ground to how we can address the concerns of the commissioner, because that letter showed that the concern was mostly about logistics and the mechanics of disbursements of funds. And again, we did not receive any response to that invitation for an in-person meeting. And I just want to say that the reason why we suggest an in-person meeting is that we're trying to learn from, we're trying to really benefit from lessons learned in terms of the ways in which the relationship between the parties can sometimes descend into very unhelpful dynamics. And at the May meeting, I thought that we had all agreed that in-person meetings might be more productive because written correspondence sometimes just ends up either being misunderstood, or there's not much accountability sometimes with when we send a letter as to how it will be received. Our tone might be misconstrued, and we were getting off of a very tense dynamic between the parties. So I think that we had agreed that in-person meetings would be better. Following that letter, my clients had some reaction to the tone of that letter, to be quite frank. And so we decided that instead of sending back a letter that might just exacerbate tensions, let us sit down and let us talk, because the issues that were raised were, in our view, issues that could be easily resolved.
Okay. Yes, Justice Anderson.
Yeah, thank you very much. Ms. Mendez, I wanted to start by just expressing my appreciation for what you said about the May meeting. I'm glad that you had a meeting, and I'm glad that it was positive. I'm glad it was fruitful. Now, one of the things you said that arose out of that meeting had to do with the roadmap. And if I heard you correctly, you were saying that you were under the impression coming out of that meeting that the roadmap was not finalized. It was still to be finalized, so that you were a little surprised when you saw subsequent indication that the government thought that it was in fact finalized. And you say that instead of some tweaking, which I presume you could have lived with, there were substantial changes. I wonder whether you could tell us what those substantial changes were.
Yeah, so for instance, I don't think I can go into every single point that we raised, but just to make the point that it's not just tweaking the December 2018 agreement, and it's not just an issue of timelines. For instance, what had been discussed and agreed upon between the parties with respect to how the legislation would be drafted has been completely changed. If the court might recall, and this has been on quite some time because we haven't even gotten much to legislation, but the court might recall that what the parties had agreed is that there would be a team, a legislative drafting team that would have equal representation from both sides. We would try to get to some consensus with respect to what is in that legislation. That has been completely changed. The ways in which the consultation has happened, there's no team, there's no equal representation from the appellant. So we really wanted to engage in the substance.
Just a minute. Is there representation from the appellants?
No.
You said there's not been any equal representation. I'm asking whether there has been any representation.
No, the roadmap, as I understand it, does not really make representation of the appellants. What it envisages is a form of consultation that, in our view, is one, not very manageable, and two, not one that allows the parties, and especially the appellants and the Maya communities, to really engage in a structured conversation with the other side. So there's this open sort of consultation that is envisaged under the roadmap. There are also certain things that are, one of the other things that we raised is, if I might now go to another point that we raised, is the third party inventory. So in the third party inventory, it's an initiative, it's an exercise to identify what are the non-community interests within that might be found within the boundaries of a particular community. So it's to conduct a sort of survey to get a sense of who are the third parties that we will have to engage and try to get to some agreement as to how we move forward now, considering that there's a competing interest. In the roadmap, there's a very concerning statement that says that in the inventory process, the communities will have to give a statement. This has not been consulted, this has not been agreed upon, but the communities are to give a statement saying that they are agreeing to the continued presence of the third parties within their communities. That's bypassing an entire process where the communities can engage and try to find out exactly how we will resolve these competing interests. And we find that to be very concerning because certainly it's not to say that third party interests are irrelevant. I think that they are very important, but I think that our position would be that these competing interests, these disputes would have to be determined on a case-by-case basis, giving the opportunity, the communities the opportunity to make representations, as well as the third parties to make representations as to whether they should continue living in the community.
So, Ms. Mendes, I'm sorry, I thought you had finished your points. But what I'm hearing, okay, thank you. What I'm hearing from you, Chair, if I may, what I'm hearing from you is that these points And some of the other points that you raise, you are confident that an in-person meeting could be very useful and could address many of them. Because quite frankly, they don't seem, earth-shattering. They seem to be something that reasonable people can put their heads together and work on. Would you agree on that?
Certainly. And that was our impression after the May meeting. To be quite frank, I thought that that point was accepted. I thought that that point was made, and it was following that meeting that we were invited then to make our comments in writing. Again, these are our positions with respect to these components, but I think we understand that there will be some compromise. An issue of having this blanket resolution to third parties' interest is not a small thing. It's a very drastic step to take. But from that initial meeting, and let me just contextualize a little bit that meeting. That meeting was for the parties to re-engage and sort of find a balance with each other, because the relationship, the dialogue had really broken down at the time. So that meeting did not intend, we did not have any expectations that we would get to a particular resolution on these issues, but really just get a sense of each other and find ways to move forward. Point out what have been perhaps steps, statements said, attitudes adopted that were not very helpful, and then try to find a way as to how to move forward. And so following that meeting is when we put our comments in writing. What is the point here at this? What is the fundamental point or concern of, from the appellants? It's not how we resolve these issues. I do want to highlight that they are serious issues, but rather that we have gotten no response to that written,
Yes.
to that written communication.
Yes, Ms. Menez, I think we get that point, and it comes very clearly through your report as well. I want to drill down though. So one, you have an issue with the drafting of the legislation and the absence of an opportunity, in your view, for the appellants to make a meaningful contribution by way of consultation to that drafting. Second point you raised had to do with third-party interests and the inventory of those interests. I just want to find out from you, do you have any other major concerns with the roadmap that you say has undergone significant changes? Or those are the two major ones you have? So.
Well, those are the ones that come to mind, but I could definitely skim our communication to the other side. But those are kind of the that come to mind.
Okay.
And the way in which we try to agree to this roadmap, again, on the last hearing before the court, I do believe that my learned friends on the other side represented that we would try to get to some agreement on the roadmap, right? So that was the ultimate aim.
I follow that in this kind of recount. You're not going to pick up every single nuance of difference, but I just wanted to be able to highlight the big ticket items, because after all, that's what we're here for, I think. We're trying to, good morning, I have a meeting now. I'll speak with you later. Thank you. I will speak with you later. Okay. Yes, sorry. I was saying that we want to be able to identify the big ticket items so we can make progress. I mean, the smaller ones we have to deal with as well, but they're not quite as obstructive, perhaps. So those are the two major ones. I wanted to ask, yes?
Apologies, could I just add one to that?
Yes.
Is the village bylaws. Our position is that the village bylaws are really outside the scope of the consent order, and we want to be able to protect the internal processes of the communities. So we did have some concerns as to how exactly is it that the government is intending or envisaging this development of village bylaws in a context where we know that the village has its own decision-making powers, its own processes, we would not want the government to come in and define those things. So that is one that we do believe that we would want to address. But our position was that this was outside the scope of the consent order. So perhaps we can put that to the side.
Okay. I wanted to ask you about the FPIC, because I know the last time we were together, that attracted quite significant discussions. And Professor Solari was very helpful, as indeed was the expert from the government side as well, in navigating us through the FPIC. One of the main concerns, as I recall it, that Professor Solari and, well, most of the persons who contributed to that discussion had in mind was the nomenclature, the naming of the FPIC. And I think it had called for informed consultation. And I think perhaps a consensus, I'm hoping Mr. Attorney for the government, that I'm not speaking out of turn, but I thought the consensus was that maybe that was not the right terminology, and that prior informed consent was in fact the correct terminology. I thought I read somewhere that adjustment had been made. Yes. Are you in a position to confirm if that's the case?
Yes, indeed, I am in a position to confirm, and it was at that May meeting that in fact we were informed that okay, we will change the name and we will put consent. So yes, I can confirm that.
Okay. And has that change been effected?
Effective meaning, have we gotten a copy that says that? No.
See. Okay.
Just before you go on to another topic, Mr. Sanderson,
yes.
That protocol, do you have a copy? Is it finalized as far as you are aware?
Apologies, Your Honor. I think I missed that.
Yes. Is that protocol, has that protocol been finalized as far as you are aware?
As far as we are aware, and our position is that we still have some objections to issues with respect to the FPIC, which again has been communicated to the government, but I understand that the government's position is that it has been finalized. It's uncertain. So we still have issues with the FPIC protocol. And
you have not seen what you think the government regards as the finalized version?
Well, considering that, no, because we've had discussions after the version that was shared with us, that was represented as being finalized, such as the name, as well as some changes with respect to the substance, and that document, no, that has not been shared with us.
See, okay.
Yes. Well, the other thing, I'm not sure about speaking about the authority in the presence of the authority. So I'm a little bit embarrassed to do that. So I'm not sure I want to go too far there. But the auto delimitation exercise, you said that 25 communities have already been completed. Is that the idea? They've given their consent. The exercise has been completed?
The consent exercise has been completed.
Okay.
Right? So the communities individually consent that, yes, we want our borders to be delimited. And so 25 communities have provided their consent.
All right. And then 15 others have signed on to inter-boundary agreements. What is that precisely?
An inter-boundary agreement is where adjacent communities, neighboring communities would have some dispute with respect to where their borders are. So we engage a process under the DPM to try to get them to mediate, to come to an agreement so that they can be good neighbors, so that to preserve the peace. The DPM does place value in getting the parties to come, in getting the communities themselves to resolve their issues. And so there are some communities that have boundary disputes, and what these agreements are is that we have supported the resolution of 15 disputes.
How does this make contact with the auto delimitation exercise, or does it? Is that different from that process, or is that part?
It's a part of the process. That it's the first step in a community beginning the process of delimiting their boundaries. One second. Does Your Honor mean the inter-boundary agreements or the consent process?
No, I'm talking about how does one, because the idea is to delimit the boundaries of the area within which the Mayan people enjoy customary land rights. So if that's the exercise, and there are communities within those boundaries, which are coming to an inter-community arrangement, I am wondering if that inter-community arrangement makes contact with the wider exercise of delimiting the overall boundaries of the Mayan community.
Yes, it's a part of the agreed methodology, actually. So yes, it does make contact with it. It's part of that process.
Yeah. Thank you.
So if I may, when you say 25 communities have given their consent, and that a consent exercise, and that 15 others have signed on to interboundary agreements, those agreements and consents have the stamp of the state, or the backing of the state? Is the state, the government, involved in that process? Does it recognize and accept what has been effected there?
Yeah, I think we would have to hear from the state on that, Your Honors, because the reason that I say that is just referring back to what I indicated earlier. The process for the state to do that is the verification process. So that's the first step. The state is well within its rights to go into the community and verify that the community has in fact given consent. And that, from our understanding, has not been done. And there was an issue about whether this will be done. I did not quite understand fully what are the implications of the letter that was sent by the commissioner that was raising issues with respect to the disbursements of funds for that verification process. So I don't know if it is we're just not accepting your money because it's too complicated, so we're not accepting your money, but we will verify nonetheless, or if it's we're not accepting your money and consequently we're not going to verify.
I want to probe this a little bit more. So the process of obtaining these consents and these interboundary agreements, that process was effected by the appellants themselves.
Yes, the consent process, yes.
I see. Okay.
Yes.
And the next step, you say, is for the government, for the state, to verify what has been done here.
Yes, and I just want to add one second, apologies.
Yeah.
And I would just like to add that that process is guided by the delimitation principles and methodology. It's a document that was consulted and agreed upon by both parties. The roadmap also seeks to have some implications. The new roadmap seems to have some implications on that document. So it's really important that we try to reconcile between the parties what exactly it is that we're doing, because there was already a document that was agreed upon and has been implemented. So it's not the appellants just doing this consent. It is in pursuance of a particular methodology that was agreed upon by both parties.
Fair enough. Fair enough. Do you harbor any? This is an awkward question. Do you harbor any? Do you have any reasons to think that the government would not validate these consents and agreements?
Do I have any reason to believe that? I think that I have reasons to say that I have doubts, simply because of the sort of very confusing communications that we've had from the commissioner with respect to the outer delimitation process itself. So again, it's not really for me to try.
I know, I appreciate that. This is why I said it was a little awkward. But when this process was being carried on, was the government made aware that it was being carried on?
Yes, Your Honors. We have had several communications with the government with respect to the consent. Again, we would tell them because we are saying this is how we intend to disperse your funds, to now come in and verify. So we would have indicated that some processes have undergone consent. During COVID, especially, we also had to have some changes with respect to the process, and we engaged the government to see if they would be in agreement. But there has just been just some reluctance to be very clear with us.
Miss Mendes, can I ask you this as President probes a little further on that? How, in fact, does this negatively impact the auto delimitation process if the verification is not done? Or is there a negative impact on it?
Well, I would think that there is a negative impact on it. One, it does create some uncertainty, I guess, about what that means, because we arrived at an agreed upon process. I would say that my, just reacting to what Your Honor has asked, at least for now, my preliminary views would also be that it would be unfair to then say that if the government did not do what they were within their right to do, what they were meant to do, that would invalidate these actions by the appellants. There has been a lot of effort, a lot of funds. We were very clear with the government as to also why we had to take some actions. And so again, there has been discussion. We would like the parties to speak, to see what are the implications, or what the government understands to be the implications of them not following through. Yeah.
Thank you.
Just one more.
Oh, sorry. Go ahead, Justice Anderson.
One more small point on this thing. You mentioned 25 communities who have given their consent. You mentioned 15 who are agreed on the interboundary arrangements. But then I think you had another sort of open-ended category of other communities. You have any idea as to how many other communities we're talking? We're talking about 40 so far. About how many other communities are there to engage in the process?
Oh, I don't know that. I don't know that figure offhand. I'm getting some instructions now, and it seems that it's 16 other communities that have not.
16?
No, that's not what he's asking. Could you clarify the question, Your Honor?
No. You had mentioned 40 communities so far. 25 who had given consent to the process, and then 15 who had agreed the interboundary lines between themselves. So I'm just wondering, because you did say that there were other communities as well that were also engaged in the process. So I'm just trying to figure out, well, how many more communities are we engaged in, or is it that the 25 also includes the 15 or some of the 15?
Yes, the 25 includes some of the 15. And And outstanding, I guess we would have 16 communities that are awaiting to be engaged in the project, in the process.
That's 1-6, is it?
1-6.
Yeah, but we're not going to hold you to that, but just an idea. So 1-6, okay. All right, thank you.
Yeah, okay, sure. So in relation to the 25 that have given their consent, the next step, as far as we are concerned, is for the government to embark on the process of verifying these consents. Is that correct?
You're muted.
Sorry, apologies. Yes, that is what's pending, or at least that's what's set out as the next step, and that is what then would give that stamp of validation from the government to the process.
What resources are required, in your view, for the government to take that step? Does it require a financial outlay or just a human resource outlay? Do you have an idea?
It seems to us that it does require financial resources, and I say that as not being in the government, but that is why there was a particular sum of money assigned to the government to undertake that particular process. It was provided for in the fundraising and in the project itself that the appellants were instrumental in obtaining, because yes, this requires resources, both human and financial. So the issue about the verification that I referred to has to do with the disbursement of those funds, because there were those funds, if there's still those funds, there are those funds still available.
In the meantime, pending the government's verification process, is it fair to say that the persons who comprise these communities are comfortable with, are abiding by, are respecting the implications of these consents?
Yes, it's fair to say that. These communities obviously are not monolithic. You could find some dissent, some concern, but through the village meeting, they arrived at their processes through consensus. They are engaged in the process. We definitely see a lot of investment and participation from members of the community in undertaking what is really a lot of work and exhausting work in terms of the outer delimitation and carrying out that consent process. So yes, I think it's fair to say that the communities are invested in the process. The ones that are engaging in it, for sure.
Okay, thank you. I don't know if any of my colleagues has any further questions of Ms. Mendez.
Not from me, thanks.
Yeah, okay. Thank you very much, Ms. Mendez. Mr. Marshall, can we hear from you?
During the period under review, the emphasis, as we understand it, leaving the May meeting, the roadmap called for the settlement of the Island policy, then the starting of drafting. And it was the first step. You'll remember that draft outline of the buyer policy was filed earlier on, I think towards the end of February. And the final policy was to have been settled, and then the policy would have been the basis on which instructions for drafting would have been given. When that draft outline was presented, it was discovered that there's a significant divergence between the views of the cabinet as a whole and the contents of that policy. It led to a reevaluation on the government side of the policy in great detail. There's been some 3 versions of it, and to date it's still not settled with the cabinet subcommittee.
Sorry, the policy that you refer to is
The overall guiding policy.
the revised roadmap?
No. The revised roadmap calls as the next step in May was to settle the policy, overall land policy of the government, Maya land policy. And that Maya land policy would have been the basis for instructing drafting of the proposed legislation. We had not settled the terms of the Maya land policy. There was a draft outline prepared by consultants and by the Land Ministry, with the assistance of the Land Ministry. And approval was sought for the policy as a whole because it would have led to the need for legislation. It's pointless to settle a policy in respect of which there's no overall cabinet buy-in, because the prospect of passing legislation pursuant to it then becomes dim. So the policy was put for overall consideration, fleshing out. It's important that cabinet and the government owns that policy so that the support for passing laws to give effect to it are there from the beginning. And we have gone through and are examining the policy in great detail to get that buy-in. So there's been significant developments under the period in review, but within the government side. So admittedly, Ms. Menes on the other side would not have had the interactions in that process, because it's only after we can settle it on our side that we can then consult with the next side as to its contents, which was the intention. So there's been much to do with that and much details to iron out. On the upside of that, it provides the detailed basis for instructions for legislative drafting. On the downside is that it involves arriving at consensus between many different people. It has taken longer than anticipated, even in the roadmap that was prepared. So that was to be done in May, and drafting was to have started soon thereafter. So we've been stuck in getting the details of the policy finalized so that instructions can be given for drafting. But that process is well advanced, and we expect it to be finished by January next year. But it will require a revisiting of the roadmap in any event, because the scope of the policy may well require not only just basic legislative change, but might well require constitutional change. And that then puts it within the realm of the recently established Constitutional Commission for wider consultation. If
I may, at what point in the development of the policy is it intended that there would be discussions or some opportunity afforded to the appellants to give their views on the policy?
On the draft. Yes, once consensus is received on the government side, we can present that as the government's position for consultation.
Mr. Marshall, was there any previous consultation before the document was sent to the cabinet?
There was consultation, but not with the entire cabinet. There were consultations with people within the ministry, with the experts, and with the technical people who prepared that draft.
And what about with the appellants?
The appellants, were they consulted? No. It was just presented as a draft. It's just a draft showing where they wanted to go. But it's an important document because a lot of concepts need to be clarified, definitions settled, that will inform and feed into the legislative drafting. But again, it's important that we get consensus on that on our side before we were even able to share it. And that is where we were.
I'm a little puzzled as to the process, quite frankly, because yes, I hear you that you need to get some consensus on your side, but if you're developing a policy which is to affect stakeholders, and in this particular case, it's not just stakeholders. This is a policy that emerges out of and seeks to give effect to a litigation, a consent order, an order on which there is a group of people on the other side. And so they have as much stake, as much interest in the policy that is developed as the other party to the litigation has. And so I am not sure that I understand the process that is taking place.
The process, simply put, is for us to produce a draft to show it as what it is the government is prepared to do and to consult with them. Then it's a starting place for consultation. I'm not sure how we can consult on just vague concepts without being able to say what it is that we on our side think should happen. And it is in reaching consensus on the government side that we've been working these last 3 months. As I said, there have been 3 iterations of our draft. So if we were to share, say, the first draft and consult with the other side, and then by the time you get to the consultation on our side is looking to change it substantially, then the benefit of the consultation on those are really lost.
But that is one way of looking at it. And another way of looking at it is to take the view that hearing voices, particularly of those people who are principally affected, can help to enrich your appreciation of what should or should not be contained in the policy. That is also another way of looking at it.
Well, the original draft was shared. So there's an original preliminary draft outline there that was shared. That is what it is. There has been comments received in respect of that. But what I'm saying is that, and my hope was to move towards the drafted. And because we do seem stuck in processes and to get some results. And what we're
so you want to move to a draft bill before the policy on which that bill is to be drafted is discussed with the appellants?
No, I think Your Honor is misunderstanding me. The process is to settle the policy so that you can move to drafting after consulting with the appellants on the policy. But we move no closer to drafting if you're consulting on every concept within the policy, even if there isn't consensus that those concepts are to be accepted on our side. So we wanted to put forth what we think it should be so that they can tell us what they think it should be, and we move the consultations forward from there. But where you were was a lack of consensus as to what we think it should be. And in those circumstances, we thought that should be settled before putting a position forth to the other side.
Can I suggest, Mr. Marshall, that there are 2 things. One, one of the difficulties I think we have heard this morning, and which is evident in the report from the appellants, is that there's some degree of disquiet in not hearing back from your side in a timely way. And in fact, I think a word used more than once was non-responsiveness. And I do think that, as I'm sure you'd appreciate, sir, that, you know, responding in a timely way does have to alleviate some tensions and some anxieties and so on. And even what you have said to the court this morning, I think if that were placed, you know, in some kind of correspondence to the appellants, whether they agree or disagree, at least that would give them the comfort that, you know, you have heard them and you are responding. I'm assuming, of course, that the substance of the information has not otherwise been conveyed to the appellants. But this is a point I think that our former chairman, Justice Witt, has emphasized time and again, that it is very important that there be a constant, you know, communication between the two sides so as to reduce suspicions, reduce misunderstandings, and so on. So that is one point. I don't know if you wish to respond to that. You don't have to, but I do think that that is something with respect that could and should be borne in mind, that, you know, there's a degree of professionalism as well that's involved in getting a correspondence and responding. The more substantive point to me is the one I think the president was getting at, which is the line of sight that we need to have between the deliberations, maybe agreement in cabinet on the one hand, the then agreement on drafting instructions, which I understand you to say would be followed by consultations with the appellants and perhaps with others as well, before the legislation is then drafted. If that is a line of sight, I am inviting you to reassure the appellants that any concerns that they may wish to ventilate during that stage in the process, which has been earmarked for them to be able to make their views known, that can still be impactful on the process. In other words, even though Cabinet has agreed that this is their policy position, they are still open to the possibility of adjusting that in light of representations, consultations that may be made further down the road. Because unless that's the case, then the president's difficulty is also my own, that, you know, you'd have waited too long for the appellants to be able to give that chance to impact the process. So I'm just asking you to respond to either or both of those comments, if you wish. Thank you.
Yes, thank you. Yes, maybe there can be more communication as to the status of where the policy was. I think the trouble was that the correspondences refer to specific items that would have been affected by the policy, and given the uncertainty, there may have been some uncertainty as to how to respond in a way that there's absolute commitment on. But yes, there can be more communication, and that would help, and we can seek to undertake to do so. As to the adjust representations, given the divergent views within the government side that the policy itself has provoked, we fully expect that there will be other views being offered when it is presented to the other side. And all of them will have to be considered. And the government is open to considering all of it. It's finding consensus on a good starting place that has been the issue, because the matters raised within the policy has given rise to such views even within the government side. So much so that the suggestion has gone as to possible constitutional amendments as well being incorporated within the policy. So it starts off as drafting legislation to protect the rights as they exist within the Constitution now. It's morphing into properly defining the relationships, even if that involves adjusting constitutional limits. So that's kind of where we are, even in terms of starting the conversation. And that has been the issue. But my fundamental difficulty was in moving things along is that there seemed to have been a disconnect between the decision makers and the words on the document, and a lack of full appreciation and buy-in to them, so that when these things are being expressed as needing to be done, you're getting reactions of shock and dismay rather than, yes, we're on board, we know that, let's do it. So it was a matter of clearing all that away, all that debris away, and finding some consensus on what we can do to move the whole process forward and achieve some tangible results. And we thought the starting point for that is for us to get together on our side and get consensus and get ownership of some of these ideas, and then share them, and then seek to adjust, consult, redefine as the process requires. Our difficulty was that among the government side itself, there were differing views as to basic ways forward.
And I don't think anybody on this call would want to underestimate the difficulty. It is a real serious legal concept that we are trying to carve out here, and it does require, as the president says, of course, the buy-in of all the relevant parties. I would imagine that the government is being assisted by the required expert advice, because that obviously is going to be very critical. I am not, of course, going to go into the issue of the authority here, but it seems to me that wherever the expert advice is coming from, that is going to be really quite critical in shaping a land tenure policy, which is both consistent with the Constitution and, of course, consistent with the integrity of the traditional rights to be enjoyed by the Mayan people. And I think that there are, of course, other places which have gone this road before, kind of thing. And Guyana is probably somewhere that one could look at to get some ideas as to what might be possible or might not be possible. But the point is that it will be useful for the government, I think, to get as much expert advice as it possibly can. And I'm sure that Ms. Mendez will agree that she is somewhat comforted by your assurance that the point at which the consultation takes place will be impactful in the process. It won't be a fait accompli, but that the Mayan people will be able to meaningfully involve themselves in the process. Thank you.
Yeah, Mr. Marshall, if I may just go back to a point that Justice Anderson raised. I take it then that what the cabinet will be agreeing to is a draft policy for consultation with the appellants and perhaps others. I don't want to go down there, but I take it that that is what will come out of the process that is before, I think you said, the subcommittee of the cabinet.
Yes, indeed. So we're moving from what was a draft outline to a draft policy, but it's fleshing out and clothing a lot of those concepts. And yes, it is a draft policy for the purposes of consultation.
Thank you very much.
I want to take you to some of the specific issues that were raised and discussed with Ms. Mendez, because I am not sure whether it is that some of these issues have been put to one side and have been overtaken by a new overarching policy about which the appellants, which the appellants have not been involved in trying to give their views on, to shape that policy. The FPIC protocol, what's the position with that?
It was being translated. It's being applied in a number of instances. And the translated protocol does have the name change in it. They were working to translate them to Mopan and Quechua languages.
Ms. Mendez says that she has not received a finalized version.
I am being told that the translated versions were included as an annex in this very documents file. I think the translations are only just being completed. It's being done through the Guatemala agency.
But were the appellants sent an English language version of the final copy?
With the new title? I don't think so. I don't think that's...
Mr. Marshall, I mean, I don't know. I don't quite understand how this process is evolving. Because all of this, that is being done arises not out of the government's own deliberate desire to do what it thinks best for Belize and its people. It arises out of a litigation. And it arises out of a litigation where the parties consented to an order. Now, this is a very novel, awkward kind of order because it is one where one side of the litigation has the responsibility of implementing that order. But they have to implement it in good faith and in a spirit that respects the fact that the implementation emerges out of a consent order where there are litigants on the other side. And I am disappointed to hear that the FPIC protocol, which is an important aspect of implementing that consent order, could be finalized by one party, be implemented, and the other party has not seen the final version. That is very disappointing.
I understand what Jan is saying, but I think to put the side of the commissioner forward, you gotta change the title. They have the policy. You're talking about a piece of paper with a word change.
You see, the international community is keeping a close eye on the way in which this entire matter evolves, the way in which it develops, because the problems that it seeks to address are problems that other countries also are grappling with. And the reason why this court became involved in the monitoring process is that one, is a very complicated, complex order to implement. But more so, you want to ensure that there is a neutral body standing between the parties to keep them on the straight and narrow, to try and ensure that the court's order is being implemented with integrity and in good faith, because it's an order of this court, even though it's a consent order. And so we also have an interest in the manner in which it is implemented. And the international community also is looking on at the manner in which it is implemented. So I would hope that in short order, that finalized version of the protocol is made available to the other side.
I think that can be done before the end of the day. It's really not significant. I understand the significance of it as you have explained, but in terms of actually doing it's really not a big deal. So we can do that before the end of the day. I think that was probably just oversight. As we reported, the emphasis with the FPIC, so far as the preparation and documentation was concerned, shifted towards securing formal translations of it. And that effort has been ongoing for a number of months and is now completed. So those have been shared. And the English language version is very easily shared.
Well, that's a start, because the versions in Quechua or whatever other languages, one would imagine in due course, as and when those are also done, that they are made available. But what's the position with the roadmap?
The translations have been made available. They are Annex 7 in this report. They were just completed. The position with the roadmap is that we understood and we regarded the next steps as the settlement of the Maya land policy, which was called for towards the end of May, the date. And then the next item would have been the starting of the drafting process. As I said, we immediately after the moved towards the settlement of the Maya land policies in an attempt to meet the deadline. And those were the difficulties encountered with regard to the finalization of the policy, which is still not yet finalized. Once that's finalized, it goes through the consultation process and then forms a basis for drafting. I noticed the substance of the first set of complaints being non-responsive as to drafting and who gets to draft and how in a roadmap, because I think the roadmap suggests that the government produces a draft and then submits it for review. And I think the other side is pressing for the drafting itself to be done by a team comprising drafters that they appoint. And that's the difference there. But we didn't even reach to that we didn't even reach to that point because we were stuck on the finalization of the policy.
What are the plans for engaging the appellants? They say they've written, letters, no response.
The letters, the communications are handled through the office of the commissioner, and we will seek to centralize some of these. I understand too that there's, with regard to the inventorying of third-party rights, that their dealings directly with other ministries. We'll need to centralize the communications, and we'll have to supervise the timing of responses.
Ms. Mendez's views that in-person communication is more productive and, you know, it's better than exchanging letters.
Sorry, Your Honor, we lost.
Yes, well, Ms. Mendez had said that they were keen on, from time to time, not every Monday morning, but from time to time, having in-person exchanges in lieu of writing letters and receiving written responses. What can be done to facilitate that?
We can facilitate that. As I said, the trouble on meeting even face-to-face on some of these issues, or having a clear, definitive position from our side as to what is to be communicated. The policy is really the starting point, and it's dealing with it in a level of detail that impacts all of that. And we really need to get that settled in-house so that all of that can move forward. I think part of the problem has been sending mixed messages to the other side. We need to be definitive on what we will do and how, and instead of being focused on processes, being focused, giving due regard to the substance of what it is we're supposed to be doing. So we've gone straight to that substance and we're seeking to get that resolved. And it may have been at the expense of neglecting some of these processes a little, because of the need to pin down how it is that some of these things have to be dealt with in a fundamental way and getting a commitment on them. But I appreciate that, and in-person meetings, certainly, we are happy to facilitate that. But the person sent really does need to know the scope of what he's authorized to say and do.
I see. And the auto delimitation process and the verification process, the appellant said that they've gotten 25 communities to have given their consent, and of these communities, 15 have signed interboundaries agreements. What is the approach of the government to these developments?
I was getting that from the commissioner a little while ago, as I understand it. The consent is the first step in the process, the very first step, so they're very preliminary. And as I'm understanding my friend, she's asking that government undertake a verification after the very first step, verification process. And that step, that verification has not been done. I also understand from the commissioner that doesn't stop the next step from being taken. In that the next step is moving towards the agreement, interboundary agreements. And a number of those have already been achieved. So the process is moving along even without the verification. As to why the verification hasn't happened, I'll need to get some explanations for that. But I really don't see any real difficulty in the verification of just the consent. I mean, I see it as really a small detail.
So
given
what's
the
important?
magnitude of the problems we've encountered in the policy.
Right. So the next steps will build on what has already been achieved in this regard. Am I correct? Is that correct?
That's fine. I'll ask the commissioner to tell us what was the problem with the verification of something.
Your Honors, I just want to put in context the auto delimitation. As Senior Counsel said, the preliminary activity is for villagers or each village to give its consent.
Right. And I gather that has been done.
Right. That has been done. However, each village may have up to 5 or 7 interboundary agreements that they need to sign.
Mhm.
So while the appellant have said that 15 have signed interboundary agreement, 15 of these communities have not completed a full auto delimitation of their boundaries. Some of them have about 3, 4, 2 boundaries that they need to sign. So to maximize resources then, our view is that once a village has completely auto-delimit its boundary and sign all the boundaries agreement with its neighboring village, then it will be prudent to go to that village and complete the verification of the consent on the boundary of that particular community with its neighbor. But so far, in relation to the boundary, most of, I think, if I'm not mistaken, there's only 2 communities that have completed the full signing of interboundary agreement, and those 2 communities were done by other organizations assisting those communities. So I think to maximize use of resources, I urge the appellant to ensure that all the villages, the 15 and the 25, complete their interboundary agreements, and then we go in there and verify their full boundaries and their consent, so that when we complete that, we move to the village knowing that we have done and complete the exercise with that one village.
But this sounds to me like an exercise that can be done collaboratively, in the sense that the work that the appellants are doing is work which, if it is done effectively, you will respect, and you will then carry out your verification of what is done. In other words, it isn't that they're going along on their own path and what they do is just something which is of little or no value.
As I understand it, the verification is in accordance with agreed principles and methodologies. So it's just making sure that these principles and methodologies are followed and the results produced conform to them.
Yes. Well, as my brother has pointed out, the issue with Professor Silorio is an invidious one, and that Professor is here with us.
I wonder.
Yes.
I can address that, George.
No, but I want. I think we're in your hands, sure. But I wonder 2 things. One is whether we couldn't give Professor Silorio an opportunity to address us on the issues which may have gone forward, in case she has any views that she wishes to put forward, and then perhaps in her absence we could go into the issue of her contract from the government's point of view. I will just observe that whilst Mr. Marshallek was in agreement for a face-to-face, I think we might need to go a bit further and tie down a time period within which that might take place. Thank you. So, Chair, we're in your hands, but if you are mindful, I don't know whether Professor Silorio may have something to say.
I agree with all your suggestions, so let's take them one by one. To go back to the face-to-face, I agree entirely. Mr. Marshallek, the court would like to get from your side a time frame within which there would be a face-to-face with the appellants.
Yes, Your Honor. The difficulty with the face-to-face is not the people here. That face-to-face is normally with the minister, last time it was. and somebody in a position of authority at that level to make decisions. That's how the decisions regarding the title and the changes agreed were achieved. And while I can speak for my own schedule, I can't speak for her. She was intending to be here this morning and was called away yesterday to another matter. So if we set broad boundaries or give
Yes,
enough
broad.
schedules,
Say
we can
before
probably
the end of
do that.
January. Is that a?
No, certainly by the end of January.
By the end of January,
Right now-
that sounds fine, because as you get into
Right now-
December, then year-end activities kind of supervene and, okay, so
Right
that's
now,
one.
I can say that the way forward right now is we're trying to plan a 2-day session with the subcommittee because we want to start and work through everything. We find that the regular meetings or a couple hours, we're barely scratching the surface of the policy given the divergent views that generally come forth. So we have that scheduled we're trying for December with a view to try and finish it up by January. So a face-to-face meeting towards the end of January, then we might be able to present a draft of the policy and move matters forward then.
Yes, okay. And Professor Silorio, could we have any views of yours on any observations on the issues which have been discussed?
Thank you so much, Your Honor. And I wanted to start by thanking not only the parties, but also, the court, for allowing me to serve in this capacity and for inviting me to these hearings. It's been an honor to really be able to contribute in some way to this very important process. And I do have a few remarks and reactions to everything that has been heard today, but I wanted to start by saying that it is the first time that I hear that there's an intention not to renew my role. And I wanted to just to share and very briefly, because I don't want to spend too much time on that a lot of the discussion that you've been having today about non-responsiveness and lack of professionalism and lack of information, that has been my experience too from the government side in serving in this capacity, especially after I started issuing reports with recommendations. I have been working with a government that has been largely non-responsive. I'm currently without a contract. I've been without a contract for about a year or more now. The last dialogues that I had with the government were in April of this year, but it's been challenging to be serving in this role in a position that's associated with the beneficiary of recommendations. So I just wanted to share that from my side. But I wanted to focus more time on 3 things that I think are very important to keep in mind, especially given that this might be the last time that I address you in this capacity. One of them is that a lot of what I've tried to do in my mandate is issue reports that reflect or analyze the situation and the potential non-compliance with the CCJ consent order in light of international law, in light of, obligations actually that have been assumed already by the Government of Belize, under different treaties and principles of international law. And I have produced 12 reports and also a number of technical opinions and also a number of requests for information. And a lot of the idea or goal behind this report has been to provide a roadmap of how to properly comply with the CCJ consent order. And I hope that work will continue on, that it does help as a tool, for the parties to be able to address a lot of the challenges that they're still facing. I also wanted to highlight that a lot of the discussion that we have been having today about the EPIC protocol and the legislative process and the auto delimitation process and also the land tenure policy, these are all facilitators of compliance with the rights of the Maya and indigenous peoples in this context. It seems that we're very close. It seems that progress has been made. It seems that we're close. It's just that we're not quite there. And I do hope that these progress in some way continues. And I wanted to salute, the work of you justices and the CCJ monitoring this process, because I do notice that your intervention in this process has really facilitated that there's more progress, even though we're still in an environment of a lot of challenges. And I just wanted to close by saying that one thing that I've observed and that really concerns me in this process is process. The reality is that even though we have steps, to comply with my reports, that we have steps to produce these important facilitating tools, every time we come to one of these hearings, and even when I did my visits to the villages, a lot of the concern was the lack of a climate of confidence. The lack of a constructive climate to be able, to reach these tools and to be able to negotiate solutions, and process is very important here. The way information is shared on ongoing processes is very important here. Consultation is very important here. Representation is very important here. So a lot of the issues that have been discussed today are really latent here. And the reason why international law and all these bodies keep on talking about these issues is because indigenous peoples historically have been excluded and still very excluded from a lot of decision making, especially at the government level. So I hope the process continues, basically shedding light, on the importance of that climate of confidence, because it's very difficult to really accomplish much without it. And I also just wanted to close by saying that international attention is definitely on this process. I get questions all the time about this process. I work with numerous international entities. There's a lot of attention because there's a lot of hope behind this process, right? That something good could come out of this process. And I do hope, that there's a way, to move forward, because this is one of the most promising processes, that we have internationally right now, even though it's very difficult and complicated. This can be a really, really good, step forward, in compliance with the rights of indigenous people. So I do hope that there's a way to move forward. And again, I just want to thank all for the opportunity to serve in this capacity.
Thank you very much, Professor. Does anyone wish to ask the professor any questions? No?
No. I think I would just like to acknowledge the expert here, the authority, for her continuous engagement in this process, and to thank her for the work she has done so far.
And if I may, President, I suspect my sister would want to also join in what Ms. Mendez just said. We over the course of the past few years, really enjoyed the tremendous support that the professor has given to us as a monitoring tribunal. We are very respectful of the views that she has expressed, and we think that she has contributed significantly to the progress that undoubtedly has taken place so far in the process. So we just want you to know that, Professor, maybe my sister might wish to say something of her own, but on behalf, the president is sitting in the courts for Justice Witt, but on behalf of Justice Witt and Justice White and myself, we want to really thank you very much for what you have done thus far in the process.
Yes, thank you, Justice Anderson, and you do speak for me in thanking Professor. Thank you for your balanced and mature approach to some of these thorny issues, some of the difficulties that we've encountered. But thank you for always shedding light on how we can take next steps that will progress what is an important, and you at the end you said that there's a lot of attention being paid to this process, and there's a lot of hope. I heard that word. I took a good note of it, so that I do hope that the parties who are listening understand that this goes sometimes, or it does go far beyond the borders of Belize, so that I do share the optimism of the persons you say that have approached you through the years. And so again, thank you for contributing so much to the process. And if Justice Witt were here, he would also have something to say. Thank you.
Yes, well, this is the first time I am meeting you virtually. Professor Silorio, and on behalf of Justice Witt, who has reported to us as a bench of the value that you have brought to the working out of this complex consent order. I wish to endorse all that Justice Anderson and Justice Rice-Notley have said, and to thank you for the role that you have played, and to wish you all the best. Of course, we will have a discussion in your absence about the future, but we certainly very much appreciate your role, your interest, and all that you've done to assist the parties in this matter. Thank you very much. Okay, so Professor Laurie, you're on mute, but we expect that you will, I think we can send you the link so that you can view the proceedings. But certainly those aspects of the discussion that concern your contract and the like, we would prefer if we can discuss them in your absence. So yeah, all the best to you. Okay. Yes, Mr. Marshallek, you had said that you were on the verge of saying something when Justice Anderson intervened, and in relation to Professor Silorio. You're on mute. Yes.
Yeah. Professor Solorio, as I understand it, was serving on an annual contract. And
Yes.
the decision was to move away from the annual contract and to engage on a per job basis. The annual contract had led to an assessment by the tax authorities and confusion over whether or not the amounts of our invoices were being paid, because it was subjected to some withholding complication because she's a foreign consultant. It led to much confusion. So the idea was to shift away from the annual contract and just engage as the need arose on a per job basis. And that was partly informed by the circumstances that there hasn't been any new complaints since November last year. So we've gone pretty much a full year without any new complaints. But that was the issue as I saw it, and the correspondences I saw. So she was alleging that she wasn't being paid the entire invoices, and there was this confusion over this tax that had to be sorted out. And coming out of that was a decision to avoid all of that by doing it another way. And that's really what it was about.
Ms. Penders, do you have anything that you wish to say just on this particular issue?
I think we've said what we needed to say, Your Honors. If it is that the government intends to go that route, again, we urge that that's not what it chooses. But I'm still unsure what is meant by on a needs basis. Who activates that? How do we activate it? When we decided with the assistance of the court, agreed upon the appointment of the authority, it was a discussion that the parties engaged on as to what will be the process, what are the terms. So I'm very unclear as to what does it mean to be on a needs by needs basis. Is it that communities can still send complaints to the authority and that's when it's activated? Yeah, I'm not sure. Furthermore, I don't know if that also means that we lose the assistance, the invaluable assistance that she gives to this process during this hearing. It's very concerning for us because, as I mentioned, and it's not just me mentioning, it was a large part of the respondents' report. There is an increase of projects that are being proposed in the communities.
President, I don't know if this would be one of the the topics that could be discussed in that face-to-face meeting? Would that be helpful or not?
Yes, from my perspective, it's simple, it's mechanics. Because Professor Salara can send an invoice for what she's done today and it will be settled. The difficulty arose out of these annual contracts. And as I understand it, if she remains appointed as the authority by the court, then her appointment stands. It's just a method on which she's engaged and how she'll be paid, remunerated for what she does. The annual contract approach had led to those difficulties. And it took some doing to get it sorted out in the end. And to avoid all of that, as I said, that was the suggestion and the decision that we don't do it that way again.
So if I understand you, then nothing changes. It's just that she is remunerated on the basis of work done on an ad hoc case-by-case basis. And if the court thought it useful, appropriate, we could also invite her to attend these proceedings, and she'd similarly be paid for that engagement. Am I understanding correctly?
Yes, that's my understanding. But there wouldn't be that annual engagement.
Yeah. Okay.
Yeah. Currently, it was an annual engagement that carried a package which was irrespective of what occurred during the year. Is that it?
Yes, this was just a total figure.
Okay. Well, when the two sides meet, I know that you will discuss the issue of if at all this alters the process by which matters used to come to her, and if so, in what respect? And if it does, what are the new procedures and what guarantees that those new procedures, if there are any, has the level of integrity which characterized those that it replaces. I don't wish to get too much into this because I think that both sides can discuss this when you meet. But if it is that, as we all seem to have thought, from what I have heard, Professor Solorio added something very useful to the process, then we want to make sure that we continue that benefit. And if it has to be by another mechanism, that mechanism similarly adds value. We don't want to, in other words, having enjoyed a process that is useful, to ditch it and to proceed to one which does not add the same kind of value. But I would like the parties, when they meet sometime by or before the end of January, to discuss this some more and hopefully arrive at some consensus. I know that there was something about the Office of Indigenous Affairs looking into disputes. All I would say is, and I agree with Professor Solorio on this count, process is important, you know. One needs to know what are the procedures. Have they been set out in writing beforehand? Does everybody know them? Do those procedures have integrity to them? So I leave it to the parties to engage on those issues. I'm happy to hear that it seems as though it's a mechanics issue and nothing substantially changes, but it is just a question as to how the engagement is structured. If that is really the case, then I think that certainly provides a little comfort.
President, if I may, yes, just to sort of go back to something that a professor raised today, and that is the whole question of the confidence of the parties in the process again, when she spoke of the importance of process. And I think I would like to join you. You speak of integrity of the process. I would like to speak to the fact that the process must build trust and confidence. So that I do hope, like you, President, that whatever process is employed going forward, that trust and confidence can be gained from it. And we will not hear that it is not a process that can be trusted. So, but I'm sure that when the parties meet, they will speak frankly on this matter. Thank you.
Absolutely.
And of course, President, I meant to say, I do believe that on the last occasion, I may be wrong, but when the parties met in their joint meeting, they produced a joint report. And we might want to ask them to do that on this occasion.
I agree entirely with you that when the parties meet, it would be useful on that occasion to produce a joint report, and also when there are hearings before the court, for them to see whether it is possible to also produce a joint report to the court. Of course, we don't expect that there would be consensus on every issue. But every opportunity that can be had to get the parties to meet, to discuss, to, air their various divergent views on issues, I think is helpful. Just communicating one's own approach to an issue to the other side who is affected is helpful. Something that you may not have appreciated or noticed, you get to be aware of it, and that helps to modify your own position. So let's try and maximize those opportunities. Is there anything further that we need to engage in at today's hearing?
President, do we need to fix a date for the filing of the joint report? I don't recall if we did on the last occasion. Perhaps Ms. Mendez or Mr. Marshallek could assist.
That might be a function of when the meeting takes place.
On the last occasion, I think that we had agreed that either a week after the meeting or 2 weeks after the meeting, we would report back to the court. If it went well, presumably, and the parties can come to some consensus as what's in that report, then a joint report would be provided. If there's divergence and something went awry, I guess we would produce individual reports.
Yeah.
But perhaps 2 weeks is a good timeline.
Yeah. Why don't we say that you meet by the end of January, and maybe we can set another monitoring session towards the end of February? Is that too soon, or is that a reasonable? What has been the habitual interval?
Maybe the JC could help us with that, President.
Yes.
The point is that it would be nice to have something concrete for us to monitor,
Yeah.
So that if it's just a meeting which has taken place, and we get a joint report on that meeting, that might be sufficient for that purpose. And then we take a bit longer to
Right.
Yeah.
Well, so let's meet in February, and so that we can get a sense of how productive that January meeting was, and see how we can help the process along. And then after February, maybe there's a longer interval before we meet. So do we set a date now? Maybe that might be best. Or do you want us to give you a date after we decide among ourselves, judges, council? Maybe it's better if we
I think it would be good for us to set a date from now.
Yeah.
That would be a
Yeah. Okay.
President, there is that little matter of carnival in Trinidad during the month of February.
I know.
And for some of us, I certainly am not one who plays Mars, but for some of us, we do get out. And we are to have the mother of all carnivals this year, as you recall, because we've not really had carnival for like 2 years. Yes. So I'm trying to look and see what the dates of travel and so on are. I wouldn't want to commit to something now. No,
Right.
not be able to meet it.
Right. Maybe.
President, sorry, I was just informed that Carnival 2023. Just now, I think I got the dates wrong. Sorry.
And then we work backwards from that.
Perhaps the 14th, I know, President, or the 15th.
The 15th.
15th is a Wednesday. Would that give enough time?
Wait a second. No, it's the 20th. It's the 20th. Monday is the 20th. I'm seeing here. Is that correct, Giselle?
President, we are checking because we had some conflicting dates. Because the dates I would have given you would have been a Friday and a Saturday. So we are double checking on Google.
The Monday is the 20th. It's Monday the 20th. Monday the 20th and 21st.
21st. All right, sir. Thank you.
Right. So
The 15th, President.
the 15th, yes. That's a Wednesday. Mr. Marshall. Sorry. Somebody said something?
Yes, I was wondering if the 28th is a convenient date for the court. 28th.
The 28th.
It's good for me, President.
I could do that, the 28th. Actually, when do I leave? Yeah, I think the 28th I would do. I'd be able to do. Well, if not myself, then Justice Witt. Justice Anderson is the 28th. Okay, Mr. Marshallek.
I need to check. Let's see.
Okay, why don't we say the 28th provisionally, and then we will confirm that with you. Later than that would be bad for me. At least for the first half of March.
That's fine. From my perspective, I do have something scheduled, but I'll give this priority. So I make arrangements. We have sufficient time.
So you should be able to do the 28th.
Yes, I think so.
Okay, well, we just see about Justice Anderson's calendar, and then we'll confirm that with you.
Yes, it looks clear for me on the 28th as well, President.
Yeah.
That should be fine.
Okay, so at this juncture, I want to thank you, Mr. Marshallek, Ms. Mendez, and your respective teams, and the Commissioner of Lands, is it? And all of you who have assisted in this process in one form or another. As we said at the outset, it's a difficult process. We knew that from the beginning. It's a process which will not yield to everyone everything that they wish. It's a messy process, but we've made a tremendous amount of progress. And when we are faced with the frustrations that invariably will arise, we need sometimes to look back and to see the progress that has been made, and to keep faith and to continue to engage. I think that is really critical, because as we said before, and as Professor Solorio confirmed, you know, the gaze of the international community is on Belize with this process. And Belize, and by Belize I mean the state of Belize and all its people, including of course the appellants, can come out looking like a shining star in the international community, being a beacon for other states that have these kinds of problems. Getting there is not going to be easy, but it is possible with all the messiness and difficulties and frustrations. But we need to keep our eyes on that final destination where we remove ourselves tremendously away from what existed before this litigation started, you know, and that would be something that we would all be proud of. As for the court, our own role is one where we have to be, you know, this is not a role where we make decisions in the sense of court orders. What we want to do is to avoid the process reaching a stage where one party initiates another round of litigation that comes up to the court. As far as possible, we want to avoid that. Sometimes it might not be successful, but with good faith and desire to see after the interests of Belize and Belizeans, I think that we can continue the process and the progress that we have been making. So thank you, everyone, and I hope that there's a productive meeting by or before the end of January, and that we meet on the 28th of February to get a progress report on that meeting and on what's happening generally. And I'm looking forward to hearing that the parties are not as estranged from each other as they appear to have been when these compliance reports were drafted. So thank you very much, and I would now invite the registrar to close the proceedings.
Thank you, President Saunders. Thank you, President Saunders. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rochnett-Lee. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Thank you.